Thought I was going to be a little late, but in Shawnee County, they're very efficient on issuing your driver's license. I went 15 minutes early, probably 20 minutes early, and they took me straight in. And they did a great job. They're to be complimented, except I didn't care for their camera. The picture that came out was not, I didn't think looked like me. But whoever that old fellow was on that photograph, I just didn't recognize. They make you take your glasses off. So I'm good for another, I think, 4 or 5 years. Or the next time they won't issue me one, I'll be too old. But anyways, thanks for everybody. I need to go through and see who's here. The IT man, tell us who's here.
We have Jordan Mahallahan, Matt Sterling, Michelle Segan, and Representative Eric Smith on WebEx.
Okay. Representative Smith, are you in the building? Representative Smith, you in the building?
I am in the building, and I'm in my room because I've got a little bit of allergies. I don't want to make anyone nervous.
We appreciate that. We're glad you're in the building. I think that, I'm trying to say, do we have Representative Potter? Is she on WebEx? Sometimes she appears on WebEx. Okay. And Representative Burris, is he on WebEx? Good. Okay. Fair enough. Folks, when we met yesterday, I pushed a pause button on the bill we were working. I'm going to take that bill up after I do this hearing because I have some conferees here and I don't want them to sit around while we're doing that. So we'll first do bill introductions if there's bill introductions. I see no bill introduction. Oh, I'm sorry. Representative Miller, have a bill introduction.
Thank you, Mr. Chairman. I would ask the committee to introduce RS 21 RS 1690. I can explain the bill, but it's often referred to as the Eddie Eagle bill.
Thank you. Matt, do you have that RS number?
I do, Mr. Chairman.
Thank you very much. Without objection, it's admitted. Other bill introductions? Seeing none, bill introductions are closed. We're going to take up first bill is House Bill 2415. Matt, if you would give us an overview.
Thank you, Mr. Chairman. Good morning, committee. House Bill 2415 would require an investigation whenever the death of a person occurred because of fire. The investigation would be initiated by the chief of the organized fire department or the chief law enforcement officer regarding the circumstances of that death. The bill would also expand the law enforcement powers of the state fire marshal. So under current law, the state fire marshal and the state fire marshal's deputies and full-time fire prevention personnel that are assigned to investigation duties have the authority to make arrests, carry firearms, and conduct searches and seizures while investigating any fire or explosion in which arson or attempted arson is suspected, or in which there is an attempt or suspected attempt to defraud an insurance company. So House Bill 2415 would authorize the state fire marshal and investigators of the fire marshal to make arrests and conduct searches and seizures while investigating violations of laws enforced or administered by the state fire marshal. The investigators who are certified law enforcement officers would be authorized to enforce all criminal laws of the state as they encountered violations of those laws in the course of their employment. And then lastly, Section 2 of the bill would clarify that any clothing or equipment that was intended to protect firefighters that was sold or purchased would be required to comply with the standards of the National Fire Protection Association that were adopted by the fire marshal through rules and regulations. And happy to try to answer questions the committee that might have.
Thank you. Questions for the reviser? Representative Heiberg.
Thank you, Mr. Chair. This may be more of a research question, but in your drafting of this, did you determine whether in other states is it common for the fire marshal to have powers like this?
I'm sorry, Representative, I don't have an answer for that. I'd be happy to look into that and with research's help, and we can get you something, but I don't have any knowledge of that right now.
Why don't maybe a conferee can answer that. You can hold
Oh.
off on that. Thanks.
Thank you. Further questions of the reviser? Seeing none. First conferee, Doug Jorgensen, State Fire Marshal. Good morning, sir, and welcome to Fed and State Affairs.
Mr. Chair and committee members, thank you for allowing me to appear here today and present supportive and informational testimony on HB 2415. As already stated, the bill does three things. Currently, in KSA 31157, the actual law enforcement authority of our investigators is not really explained. And so all we're doing is adding language to bring our agency in line with investigators that Department of Revenue, Kansas Lottery, or the Department of Labor actually have. In KSA 745602, under the Kansas Law Enforcement Training Act, our investigators are recognized as police officers and law enforcement officers, and they are certified under CPOST, the Commission on Peace Officer Standards and Training. We're just better defining the police powers consistent with other state agencies so that there's no future issues in court with the testimony of our investigators. The second part of the bill deals with fatality fires. Over the last couple of years, our office has become aware of fires and explosions that have occurred that were not thoroughly investigated. Those instances cover both first-class, full-time fire departments in major municipalities and go all the way down through volunteer departments in the state. They also encompass all different sizes of law enforcement agencies across the state. What we found are that there's fatalities at fires. They're being ruled accidental, and then later on down the road, a number of months in some cases, we find out that it was actually a homicide and that the fire was used to try and cover up that homicide. So we're just looking to make sure that any fire fatality is investigated thoroughly and properly from the beginning. And then the third part of the bill deals with the protective clothing that our firefighters wear. Currently, the statute was set on the standard in 1988 and hasn't been updated since. So all this bill does is bring that statute up to the current national standards and allows our office to incorporate the change in those standards by rule and regulation, so we don't have to come back and change the statute every 2 or 3 years as those standards are updated. And for the committee's information, I've also met with the League of Municipalities, Association of Counties, and Ed Klupp representing the state law enforcement associations this week. And we are offering at the committee and chair's discretion and proper time an amendment to the bill that just tweaking some of the language in it that everybody agrees to. And with that, I'll stand for questions.
Thank you. Questions for the conferee? Yes, Representative Howe.
Thank you, Mr. Chairman. I just had a question as it relates to fire marshals at the county level. How would this impact them? Would they then also have certain investigative powers under your authority?
No, this would not affect. Our office has a program that we call Certified Fire Investigator, and we do training, and then we do basically a permitting for fire investigators either in the local fire department or in the local law enforcement agency, but they only have that authority when they're actually working a They don't have the additional ability to carry a firearm or to do search warrants and other investigative things outside that specific fire they're working. So this would not affect the local fire investigators that the local fire department or that the local law enforcement agency.
Thank you.
Thank you, Representative Armberger. Oh, Heiberger, I'm sorry.
Thank you, Mr. Chair, and thank you for being here. Do you know if it's common for investigators in state fire marshals offices in other states to have these powers?
Other states are all different. Some states, the investigators don't have police powers, and they have to rely on local law enforcement, and they have to somewhat burden local law enforcement to do the search warrants and things like that. There are other states like us, though, that do have sworn investigators and do have full police powers in the state, so it sort of comes and goes depending on the state itself. And there are states that don't have fire investigators, and they leave it totally up to the local jurisdictions.
Representative Smith on WebEx.
Thank you, Mr. Chair. I just wanted to make a comment, first of all, that I appreciate the State Fire Marshal's Office, and I've had the unfortunate, I guess, or fortunate, depending on how you look at luxury of being able to work with this department on a number of arsons. These investigators perform investigations just like any other investigation, law enforcement investigation, including homicides, et cetera. Our relationship with the State Fire Marshal's Office has always been at the utmost. We respect them. We appreciate their knowledge and their expertise when it comes to these things. And as he said, when there's arson involved, there are often other crimes involved with it. And it's just common sense. And in fact, when I saw this bill come out, I thought, really? We don't have this already? Because of the function they have performed before. So I thank you, State Fire Marshal, for the service you provide.
Thank you. Further questions? Yes, Representative Wagner.
Thank you, Mr. Chairman. To get the scope of this, how many fire deaths are there per year in Kansas on average?
On average, I think we run in the 20 to 30 range, if not more. I mean, I think it's surprising that people aren't aware of just how many deaths we have by fire each year.
And, I mean, how many fire investigators does your department have?
Right now, we have 10.
Okay.
Other questions? Yes. Representative Carpenter.
Thank you, Mr. Chair. I'm reading the new section 1 here, and I just want to get some clarification. So it says that you guys have the authority, will have the authority to make arrests and conduct searches and seizures while investigating. So if there's a guy that you guys need to go and arrest, or would you be in charge of warrants and no-knock warrants, or going into, trying to grab somebody that you're trying to investigate?
We could be. Our investigator would probably be the one that would go to the court and the judge to actually get that arrest or search warrant signed. But it's not something that we do on our own. We also always include local law enforcement, because we don't want to be out there acting on our own and cause an issue for local law enforcement, or for them to start receiving calls from neighbors and wanting to know what's going on.
If I may, Mr. Chair. So is there anything in current law that requires you to work with local law enforcement if you're going to issue such a procedure?
Not necessarily, but we're currently an assisting agency, so we cannot go in and even investigate a fire without being asked to by the local fire chief or the local chief or sheriff. We can't go in and initiate investigations on our own. So currently we are sort of held to being an assisting agency and only being able to respond when we're asked to.
Okay, would this bill change that current process or procedure?
This bill only addresses fatality fires. And it only addresses that we're asking to just be involved. We're not asking to come in. It doesn't say that we'll come in and try and take over. We just want to be involved in that investigation just to make sure that the investigation's done and it's done completely.
Thank you, Mr. Chair.
Thank you. No further questions. Thank you. Oh, I'm sorry. Go ahead. Representative Arnkamp.
Thank you, Mr. Chairman. A couple questions. You said that you referenced something that it only is in the cases where there is a fatality by the fire. Can you restate that?
Yes, this bill only addresses fatality fire. On all other fires, we still need to be requested by the local authorities.
So reading new section 1, letter A, am I misunderstanding that? Because I don't see a reference to a fatality fire in any of that language.
I think it, with the help of somebody here next to me, I think it's in section B. And I might have to rely on staff to qualify that.
You want to revise it?
As I read it, though, section B is different than section A.
Section A just qualifies our law enforcement authority, and then section B sets out that we would be involved in any fatality fires.
Okay, and then one last question, please, Mr. Chairman. So when the laws enforced and administered by the state fire marshal, do you have a quick reference of where I can find those?
Yes, I do, and I'll have to research real quick. I can get that to you as soon as I'm done here. But the amendment actually that I was discussing actually changes some of that language and clarifies it a little bit more.
Okay, thank you, Mr. Chairman.
Thank you. No further questions. Thank you. You'll stick around for further questions, maybe at the end.
Yes, sir. Thank you very much.
Second up is Ed Klump, Kansas Sheriff's Association, Kansas Associated Chief of Police, Kansas Peace Officers Association. Good morning, Ed.
Good morning, Mr. Chairman, committee members. Thank you for this opportunity to speak with you today on this bill, which I consider to be a fairly important bill. My name is Ed Klump. I am here representing the Sheriff's Association, Chiefs Association, Peace Officers Association. Our testimony is aimed at Section 1 of the bill, not at Section 2 that deals with equipment. That isn't in our circle, so just want to make that clear. We're talking about Section 1 of the bill. And I'll talk about each subsection of that bill separately. I want to point out in subsection A on line 10, the language that's in there that this pertains to certified law enforcement officers. And it's our understanding that all of the investigators within the Fire Marshal's Office are CPOST, that's the Commission on Police Officer Standards and Training, certified law enforcement officers. They have gone under the same training standards that every officer in the state of Kansas must go under. They're under the same requirements for ongoing training throughout the year. And they certainly have been trained in every aspect of law enforcement necessary to carry out these duties. We have absolutely no problem at all with subsection A and expanding and clarifying, actually, the authority of the Fire Marshal's Office in relationship to their law enforcement duties. The language that is in the amendment that's being proposed for subsection A is consistent with other state agencies that have law enforcement officers, and there's several of those. We typically think of probably three, the Highway Patrol, the KBI, and Parks and Wildlife. But there are several others. The AG's office, for example, has law enforcement officers. The lottery has law enforcement officers. Labor has law enforcement officers. There's quite a few that have a small number of law enforcement officers. All of those are certified law enforcement officers, same as fire marshals, and this language is consistent with that. So we would strongly encourage you to accept the language from the amendment that's going to be proposed for subsection A. There has been no problems that we're aware of with other jurisdictions or other agencies that have similar authority. We work very closely with all of the law enforcement partners at the state level. As the fire marshal indicated, we try to work together on these investigations. In subsection B, there's also some amendments in that. And the reason this was an area we were really concerned with having an amendment made, if you look on page 1, lines 16 to 18, the way the bill is worded, it requires the investigation when a death occurs to be done by the fire department. And the law enforcement only comes in when there is no fire department. And I'm not sure there's any place in the state that doesn't have a fire department of some kind, either voluntary or full-time. There may be, but that would be the only time that law enforcement would become involved in a death investigation under the language in the bill. And we clarify that because we believe, and so does the other people that we worked with on this, that those investigations need to be a joint investigation. We need the expertise of fire investigators. There are unique things that investigators, the fire investigators know, and there are unique things that our investigators know about death investigations, and it's very important we work together. So we would support this bill. We support the amendments. We think those amendments are very important to make this bill work for us. And we look forward to a continuing good relationship with the fire inspectors. With that, Mr. Chairman, I'll answer questions.
Thank you. And just for clarification to the committee, we're not going to work this bill today. But the reviser has sent me your proposed amendment. I'll have 25 copies when we do work the bill. My understanding this is an agreed upon amendment from both the Fire Marshal's Office and law enforcement. Is that correct?
That is correct.
And we just didn't have time to get copies to work the bill today, but we'll probably do this early next week. And at that time, as I prefer, I'll have hard copies of the proposed amendment. At this time, questions for Ed? I'm sorry, yes, Representative Howe.
Thank you, Mr. Klump, for your testimony today. So can you help me just understand a little bit more about, under current law and this proposed legislation, what would this new legislation allow? A better communication or a better investigation? Is it public health and safety? Like, what advantages are there for this legislation and how you coordinate?
Sure, I'll be glad to try to address that. Let's talk about subsection A first with the law enforcement authority. Anytime we're conducting investigations, there are often times in the course of that investigation that you discover probable cause or reason to believe other crimes have been committed. And it's through those other crimes that we open the door to our investigation of the main target of our investigation. And target, I mean the main crime that was occurred. In this case, it may be a homicide. And so when you grant the law enforcement powers the way this proposes to do, it allows the fire investigators to act on other crimes they come across in the course of their investigation, which gives them the authority to make those Terry stops, for example, where you have to have reason to believe that crime has been, is being, or about to be committed. It gives them probable cause, or the ability to act on other probable cause events that lead us into contact with our main suspects based on other crimes that we've discovered that they've committed to allow us to work towards the main goal of the arson and death investigation. I mean, that's just a key element of basic criminal investigations, is you have to be able to act on all those. In subsection B, Like I said, it's very important, and as the fire marshal said, we want any death occurring at a fire scene needs to be investigated. You know, many times it's going to be accidental, but too many times those deaths are criminal. They're homicides, or there was an aggravated battery, and then the fire was set and to cover up that crime, and then the death occurs because of the fire, even though they were battered to begin with. And so it's very important we approach these jointly, and right now there's no requirement to do that. It was very important to our associations that these investigations be done at a local level like other investigations, and we get the assistance of state agencies when we need to. And especially in our rural areas, our agencies don't hesitate at all to make that request to the KBI or the fire marshal's office or any other state agency that we need their expertise in. For example, oftentimes we'll get involved in a fairly heavy, maybe human trafficking case or an elder abuse case, and the investigators at the AG's office have expertise in that area, so we'll call them in and then to assist us. And so we typically do call in state agencies to assist us.
Thank you.
Thank you. Further questions of referee? I'm sorry? Oh, Eric, are you on?
I am. I have a question, and Mr. Klump, this is for you, but I think maybe the state fire marshal might be able to answer it better. There seems to be a contradiction. I recall a few years ago, it was changed that arson investigators have to be certified law enforcement officers now to attend the training. Has that changed? And it seems a contradiction to what we're trying to do in Section 1 if it has not.
That's probably best answered by the fire marshal on their officers.
Could you come up? Thanks, Doug. He's passed it off to you.
That's fine. He was breaking up a little bit. Could I have...
Could you restate the question, Representative Smith?
Absolutely, Mr. Chairman. Thank you. My understanding is to attend fire arson or arson training, investigation training now, you have to be a certified law enforcement officer. However, in Section 1, it says that you have to be a member of the fire district where the fire occurred if a death occurs to initiate the investigation. It seems a contradiction of requirements between the two positions. Are we going to start allowing, say, fire chiefs to attend arson investigation and that type of thing?
Currently, in our certified fire investigator program we do allow fire chiefs, firemen from around the state to attend a arson investigation school and class so that they're more knowledgeable of when they're actually fighting a fire and when the fire is over, what they need to look for to help determine if it was an arson or accidental or anything else like that. They, however, do not have full law enforcement authority. Under the state statutes that govern our CFI program, they are allowed to carry a gun, they are allowed to draw search warrants, but it's only related to that actual fire that they're working. Most of the major fire departments in the state have certified fire investigators, and so they are allowed currently to do that under other statutes.
Thank you. And if I may, Mr. Chairman.
Please, right ahead.
It may be my misunderstanding then, sir, but I'll get with my local fire administrator and make sure of that language that I'm pretty sure he thought that they could no longer do that. So it would be great if we could have our own to help assist you guys when we have to call you.
And the confusion might be that in A, that just sets out our state fire marshal office investigators authority. It has nothing to do with the CFI program. And then in the next section, it still allows the fire chief or fireman from the local department to be involved in those investigations. It's just that they're doing those investigations with the local law enforcement agency, and then our office is also involved.
Very good. Thank you.
Thank you. Further questions? Seeing none, thank you, sir.
Thank
you. Next, we'll go to the neutrals. John Goodyear, League of Kansas Municipalities. Good morning, sir. Welcome to Federal and State Affairs.
Thank you, Mr. Chairman, members of the committee, good morning. My name is John Goodyear, and I'm a staff attorney with the League of Kansas Municipalities. I am grateful today, as I always am, to get to come before you and offer testimony this time on House Bill 2415. So we are supportive of the goal behind this bill. We support efforts to more clearly define what that law enforcement authority of the Fire Marshal's office and his investigators are. However, we're neutral on the base bill because of an initial concern from our organization regarding the breadth of Section 1A as drafted. In order to more clearly define when those investigators could exercise those law enforcement powers, we thought it would be necessary to further flesh out what was meant by that in the course language that is currently found in the bill as proposed. We voiced this concern to the state fire marshal and worked with him and Mr. Klump to reach a compromise, finding language elsewhere in a statute that we could borrow that would more clearly define when investigators can act, and we feel more accurately reflects what was intended by the legislation. So what we would be doing is replacing that in the course language with a larger statement, but the meat of that being their ability to enforce breaches of law that they encounter in the routine conduct of their duties. So to be clear, we do support that amendment. Further, we support the amendment that has been proposed for Section 1B as well. To us, it just kind of makes sense that when a body is found at the scene of a fire, that a joint investigation ensue. That way you're able to take advantage of the expertise of both, of not only fire departments and the state fire marshal, but also local law enforcement to get to the bottom of what not only would cause the fire, but also what caused the death. So with my testimony today, I included a copy of the amendments that we agreed to, and I don't know if Connie distributed that, and the state fire marshal also sent it in, but I just want to reiterate how grateful I am to Mr. Jorgensen and Mr. Klump for working with us to get to what we feel is a better bill. So we do support these amendments and would ask that as the committee considers this bill and as you work the bill, that you include those amendments if you choose to recommend it favorably. And with that, Mr. Chairman, I will stand for questions.
Thank you. Questions? Seeing no questions, thank you for coming here today.
Thank you.
Committee, I would also direct you to written only and neutral, J. Hall, Kansas Association of Counties. It will be in your folder. Anyone else wishing to appear and testify on House Bill 2415? Seeing none. And we will close the hearing on House Bill 2415. Folks, I would you that we're probably going to work this. Won't give you the exact date. It'll be Monday or Tuesday probably. Could be as late as Wednesday, according to how things go. But you know, we've got one of the calculations 12 days left, so things are going to start moving along pretty quickly. And you're probably familiar with that if you're on some of the other busy committees. If you're on Judiciary, I have sympathy for you because after turnaround, when I was chairman, you get about 30 bills from the Senate. And trying to get all those worked and cut up and put in different bills and trying to put them in Senate bills so they could go straight to conference. But anyways, we're going to move along here. I got a couple of different things I would like to do. One, I'd indicated the House concurrent resolution on Keep 9. We're going to probably get to that in a little bit. But first, I'm going to take up the bill that we had opened up yesterday. That would be 2089. And before we even start this, I think I need to make a comment. You know, some have questioned the procedural. The procedures were within the rules. I did not think that this bill was that controversial, and it's quite short. It's shorter than most amendments that we sometimes attach to bills that never had a hearing. The amendment did not. This is what I think probably 25 lines. It's a bill that we'd heard before in this committee in 18, and we had the cost of that bill is $2,500. That was in 18, so it may be 3,000 now. I don't know that. But I guess I kind of misjudged the committee. I just didn't think that it was going to be that controversial, because we've done amendments that are 3 and 4 pages long, and of course we have no hearings on those amendments. We just hear the arguments in the committee room or on the floor of the House, and we vote them yea or nay. So that did surprise me. But one of the reasons I'm doing this, it cost $1,200 for that bill that Representative Miller offered this morning. That's approximate cost. And as most people know, that I don't like to spend a lot of money. It's $1,200 for every bill that gets introduced. That's approximate cost. I thought, well, I already have a bill and I have a bill number. It's an empty bill. And I appreciate Representative Heiberger raising the issue of germaneness. Well, germaneness is not really an issue because the bill is empty. It has no contents in it. But, if I surprised you and if I offended you by doing it this procedure, it's a procedure that's used in every committee. If you're ever on Judiciary Committee, you'll see a lot of this. It's a procedure we've always used. So if that surprised you, then I would not ask for forgiveness because I've done nothing wrong. But that's my explanation. It's a process that we've used in a body in the last 9 to 10 years that I've been here. If you have an empty shells, and we call them shells, that's what we do. You'll see some more of that if we get more Senate bills, because we will take out the contents of the Senate bill and put in a House bill. And the reason we do that, because then we go straight to conference. We send it back to the Senate, they non-concur, we have conference committees, and all of the appropriation bill, or at least 90% of them, that's what happens to them. Tax bills are the same, any large legislation, because many of these issues will be decided. We have a KELA bill now, emergency management, that we put in a Senate bill and sent it back to the Senate. They non-concurred, and they're in conference. And it's going to take several days for them, hopefully, to resolve that. So I got the impression yesterday that you thought I was trying to do something under the table. Well, I don't do that. And for the one thing, I have a very good reputation up here over the last many years when I chaired the Judiciary and I also chaired this committee, is that I treat all sides fairly. I try to. Now, I know some chairmen that may not, but I have a reputation of being fair to both sides. So, with that, I just wanted to explain where I was coming from yesterday. And Representative Heiberger, if you have a comment, please go ahead.
I just want to disrespectfully offer a different opinion on part of what you said regarding the germaneness. I've had this discussion with Gordon Self, that when we made the motion to place the contents of this bill in whatever bill at 2058, that motion only affected the bill we were working, which is 2058, so that technically the contents of 2089 were still there and are still there and would not be removed until this amendment were adopted.
Okay, thank you for the comment. Representative Miller.
Point of order, Mr. Chairman. First of all, I do want to thank you. I didn't have a chance to do that yesterday, but I do want to thank you for holding this over a day. It was very kind of you, and it bolsters that reputation that you have. But as a point of order, Representative Arnberger yesterday made a motion to recommend House Bill 2089 favorably you ruled that out of order. She made a second motion to recommend 2089 favorably as amended. It has not yet been amended. I believe the proper motion should be first to amend.
No, I disagree. The motion is first because if the motion to put the contents that have been proposed into 2089, which would make it House substitute for House Bill 2089, then she would make a motion, I would get a second, we would have discussion, and then you would be able to amend it because it would actually be in a bill. Presently, it's not in a bill.
I agree. So for her to move to recommend favorably before we've even made it a substitute, I think is out of order. But that, you're the chair.
I understand that, and if that's what happened, and I don't have that kind of a recollection, she wanted to favorably pass the language into 2089. If that should pass, then they would make another motion on House Bill substitute for House Bill, or to be House substitute for Senate, or for House Bill 2089. I would take a second, and then I would open up for discussion, and at that time, it would be available for amendments.
As long as we're treating the original motion as a motion to amend, I think we're just caught up on semantics at this point.
Okay.
Thank you.
Thank you. So we do have a motion to put the language that was been proposed, which you have in front of you, into House Bill 2089. I have a second. I have discussion, and I will have discussion. If that passes, it will then become House substitute for House Bill 2089. I will then need another motion to pass it out favorably. Then, I will take amendments. If there's amendment made, and then I'll let the individual explain the amendment, and then if there's a second, the bill would be amended. When that's completed, I would look back to the original offer of the amendment, or the House substitute, to pass it out, and then if it's passed out, it will then go, committee report will be prepared, and we'll put it in on the floor in a committee report. That's the procedure. Looks, for some people, I know you're looking a little dazed, but that is the exact procedure. So right now, we're looking at, on a motion from Representative Arnberger. Yes.
I guess I want to clarify, is it the chairman's position that Representative Arnberger's motion is not a debatable motion?
No.
Okay.
The chair has called up, and only the chair can call up a bill to be worked. Then when that motion is made, and then seconded, and then offer of the contents of the other bill put in, if that is approved, there can be discussion on that portion of it as to whether or not the language should be placed into 2089. And if that is approved, it then suddenly becomes House substitute for 2089. Then I would need a separate motion to pass it out, and then we would have discussion if I get a second.
So that what?
And then it would be amendable. Then you could place amendments on it because it would actually be in a bill.
What we're doing now is working 2089, is that correct?
That is correct.
Okay, thank you.
All right. And I have a motion from Representative Arnberger to put the language, we opened it up, made a motion to put the language into it. There was some objection. I pushed the pause button for 24 hours because the issue was raised of whether we should have a hearing on it or not. At the request of my ranking member, I agreed to do this, delay it for 24 hours, to give you an opportunity. It's not a large bill, as I indicated earlier, and you've been given an opportunity, and at some point in time, if you've contacted the reviser last night, you may have an amendment if it is in fact passed into House Bill 2089, which will make it House substitute for House Bill 2089. then take a second motion, and at that time, if you wish to amend it, you may amend it. Are we all have a good understanding of where we're at? Okay, good. Just always trying to be above board. So let's go back. We have the motion. We opened the bill 2089. We had a second. The bill is open. For the purpose of putting the language that you all have in front of you into that, which is, I guess, sometimes referred to, well, it would be referred to as the Eddie Eagle. I think that's what they call it. Not in the thing. Any discussion on that? Yes, Representative Heiberger.
Thank you, Mr. Chair, and thank you for clarifying that. I'll be opposing the motion because for several reasons. One, because I'm really just concerned about the process we're using here. The representative had an opportunity to introduce this content as a separate bill, which we could have had a hearing on. The content has been introduced as a separate bill that we could have a hearing on. And so even if I liked the content on it, I would be opposing it.
I understand. But this may be the only opportunity this year that you'll get an opportunity to look at this unless it's brought on the floor of the House. And I'm not sure what it's germane to, but I appreciate that. And that somewhat surprises me because you're on judiciary, and you know how it works in judiciary. You bundle bills and do a number of different things because of the volume of bills that you do get. I know the Speaker Pro Tem, Representative Finch, when he was on it, he was famous for that.
Well, I object to that on a number of occasions, and those are all bills that we have heard in committee.
Yeah.
And although we did hear this 2 years ago, there are members on the committee who have not heard this bill.
Thank you. No further discussion? You may renew your motion. Oh, I'm sorry. No, he didn't have his hand up. Oh, he made the motion. Is that right, Connie? Okay, he says it. I believe him. Go ahead. You may move your motion.
Mr. Chairman, I move, and the bill will be called the Royale Act.
It's in this.
Roger. Yes, sir. Thank you, sir.
You move your motion. All in favor of putting the language that has been proposed in your sheet into House Bill 2089. Before I ask anything, Matt, are you following along?
Yes, Mr. Chairman. My understanding has been discussed is that the contents of House Bill 2089 would be stricken and the proposed amendment establishing the Royale Act would be inserted into House Bill 2089.
Do you see any problem as procedural?
This would be this would be a committee substitute for House Bill 2089.
Then thank you. I have a point of order by Representative Hoyt.
Thank you, Mr. Chair. So after we vote on this, then do we go to put it in there? Then do we go and have debate on the bill and as an entire, will there be two separate votes? Okay, thank you.
All right. All right, I have a motion to put the contents in and removing the contents in 2089 and putting in the contents that have been proposed by the representative. All in favor say aye. Those opposed, no. Opinion of the chair, the ayes have it. The ayes do have it. Sorry? Who was the second? The contents is in House Bill 2089. Now, Matt, that makes it House substitute for 2089 or correct?
Thank you, Mr. Chairman. It's substitute for House Bill 2089 by Committee on Federal and State Affairs.
Right. Thank you. Just want to make sure we got the right title right. Now, I will take a motion as to House substitute for House Bill 2089. Is there a motion? Arnberger.
Thank you, Mr. Chair. I move that we pass out House substitute 2089.
Do I have a second? Second, Representative Penn. Discussion. Yes, Representative Arnkamp.
Mr. Chairman, just to clarify the bill and trying to recall some of the testimony from, I don't know if it was 2 years ago or 4 years ago, just in regards to the wording, specifically shall. From my understanding, this is a mandate down to the local school boards that if they do want to have a firearms safety education program, they have to follow these guidelines, one of which is the guidelines by the National Rifle Association, which I'm certainly in favor of the organization and a lot of the efforts that they do. And it also references or any successor program. I remember some of the testimony when we did have a hearing on this bill. There was some concern about, one, a mandate down to the local school districts on curriculum, and two, the curriculum that was mandated as being from I guess a private organization that is really outside the control of the legislature or the school boards, and also to mandate a program that can be changed. And there's certainly no understanding or oversight over any changes on that program in the future. And even though I do understand and appreciate the efforts of the NRA, I think those concerns were valid. And so to more bring on some conversation just on that topic, the local control versus gun safety, I do have an amendment. The amendment was requested. It just got emailed in a few minutes ago, and I'll defer to Mr. Sterling if I may, sir.
Thank you. Matt, do you have the Arnkamp amendment?
Yes, Mr. Chair, I am pulling it up on my screen right now.
Would you, Representative, care to explain your amendment? Or do you want the reviser to do that?
I'll give it a shot there, Mr. Chairman. It simply changes the word shall to may. So it's more of a recommendation to the state school board and the local districts. They may do this rather than a shall. And once again, I'm certainly in favor of and support the NRA and a lot of their efforts. Gun safety, it's great stuff. But the hesitation I have comes from some of the testimony from several years ago with regards to mandating a set curriculum by an organization not under control of the legislature or the local school boards, and also a program in the future that we don't know what that will be. So I think it's a good conversation to have. We didn't have a hearings on this year, so this may give us an opportunity to discuss those points.
So from my understanding, we're going down to paragraph 1, which says kindergarten grades 1 through 5 shall be based on Eddie Eagle, and you're striking the shall to may. Would that be correct?
I think
all the shells. On
all the shells except the shall in the last line.
Okay.
And the shall in the last line would remain.
Okay. Thank you. Matt, could you give us an overview?
Thank you, Mr. Chairman. As Representative Auerkamp referenced, so the substitute bill currently, it is optional for a school district to provide firearm safety education programs. However, if they do offer those programs, it is required that they be consistent with the curriculum guidelines that shall be established by the Board of Education, and they shall be based on the Eddie Eagle Gun Safe program and the Wildlife and Parks and Tourism or successor program, the Hunter Education in Our Schools program. So the proposed amendment would go through and change all of those requirements that they be based upon the Eddie Eagle Gun Safe program to making it optional that they be based on that program.
Thank you. Questions of the reviser? Yes, Representative Reese.
Thank you, Mr. Chairman. Matt, on Section B of the balloon amendment, or maybe Representative Camp's amendment, if a Board of Education elects to provide firearm safety education, if a board is at a local board, is that meant to be a local board? Section B?
Thank you. Yes. So subsection A requires the State Board of Education to establish curriculum guidelines. And then subsection B talks about if a local board of education elects to provide those firearm safety education, that instruction has to be in accordance with those guidelines established by the State Board of Education. So the proposed amendment would change that to allow a Board of Education the option of whether to provide that instruction in accordance with the guidelines established by the State Board.
Representative Smith, you're on the line.
Thank you, Mr. Chair. As I recall, when we first heard this, one of the principal reasons why we asked for this type of education was because of information that was going around the country about children being told that if their parents or other household members had guns, they should report them to school officials or others. And this is one of the reasons why we said that type of firearms education was not appropriate. Telling children to report household members who own guns. Rather, there was a more appropriate education. So if you change this from a shall to a may, it opens that door again to that type of education, or what they call education, a reporting factor. And I think that's the dangerous road we tread down, allowing whatever firearms education an individual school decides to engage in. And so I'll be against this amendment.
Thank you, Mr. Chairman. The revisor explained the amendment, or the bill rather, correctly. As I discussed yesterday and on the floor last week, there is no mandate. There is no mandate. This is language that was already navigated, negotiated over a period of years. And it got to the point where they put in the language that we passed out of the House favorably, 119 yays to 5 noes. It already took into account the concept of mandating at the state board. And what it did, it said that you would have that standardized, that's the shall. But the may is for the local school boards to request. Once that request is made, it is a standardized education. Going back to your point of the representative about the National Rifle Association programming, that is not what the proposed bill reads. It says that, I'll read you the paragraph 1, 2. It says it shall be based on Eddie Eagle Gun Safe. It could be a different program. It just has to be based on those tenets that Representative Smith brought up yesterday for the education for the children. The standard right now that we have and that everyone agreed upon was the Eddie Eagle Gun Safe program offered by the NRA, or any successor program should another one come to fruition. That is the only piece in here that is the alignment for the standardization of the training for the children, should they choose to request it. There's not a mandate. Thank you.
Thank you. Representative Carpenter.
Thank you, Mr. Chairman. Real quick before proceeding to my questions, is there a second on this?
No, I want a question on the amendment, and then we'll decide if somebody wants to second it as normal.
Okay, thank you, Mr. Chairman. This question is for the representative bringing forward the amendment. I noticed that in your amendment, you strike the word shall in subsection 3 regarding grades 9 through 12, and that's about hunter safety and being taught by wildlife parks and tourism. Is there a reason why you don't think wildlife parks and tourism should be teaching hunter safety?
the answer is no. To your question framed it in very nicely. It's more about the question of local control of the school boards to develop the programs they think best fit their district. On that specific point, number 3, either way, but this certainly allows the school board to adopt the program of the Kansas Department of Wildlife, Parks, and Tourism. But it simply removes the mandate that to the schools that's what they have to base, which the way I define base is that's the program they have to teach.
Thank you, Representative, for your response. You know, I think Wildlife, Parks, and Tourism is one of the best places we could have hunter safety training offered to these individuals. And if schools are, may use them, well, then what other entity are they going to have teach hunter safety? And so I think that they have a good curriculum already in place. They don't have an agenda as far as a partisan agenda. I think they're going to go in, they're going to teach hunter safety properly. They've been doing it for a very long time, I believe. So I'm going to have to oppose this amendment, Mr. Chairman. Thank you.
Thank you. Representative Clayton.
Thank you, Mr. Chair. And just, I did want to offer a point of clarification to something that an earlier speaker had said, because I did pull my testimony from this hearing that we had in 2018, and looking just at a cursory look at this committee, there were at least 6 members that were not on the committee at the time that we had the hearing. So I'm happy to distribute any of that information to all of you, since we, old committee members like me, are privy to it and you all are not. But there was a statement that was made that children were being told to report their parents for having guns. And in my school district, we have law enforcement officers who come in and provide that gun safety. That's something that has been done as part of my son's curriculum. And that's not what the Overland Park Police Station does. They don't do that. And I think to make that implication that our law enforcement officers are telling our children to report their parents, that's definitely not happening in my area. I support this amendment because I do support that testimony. The KASB testimony that I pulled says that they do want that flexibility. And I think that this is precisely why, this discussion is precisely why we should be having a hearing on this bill, to hear from our law enforcement officers, to hear from KASB, and most importantly, to hear from Royale's family and to hear what their perspective is and to hear their thoughts. I want to hear that story. And so I will be voting to support this amendment because I always stand with local control, and most importantly, I stand with my local law enforcement.
Thank you. That's all the discussion. Now, do I have a second? Representative Miller, you're a second, correct? I'm sorry? Yes. Do I have a second? Further discussion? Oh, we have other.
I thought I was on the list, so.
No, you weren't. Sorry.
May I speak?
Yes, go right ahead.
Okay, yeah, I do support the amendment. It takes care of some of the concerns I have about the amendment. I mean, my understanding of how our system works is that the State Board of Education establishes curriculum standards, and they're not curriculum. They're just setting what students are expected to learn, and that local school districts adopt curriculum. What this bill does, as it is written now, for any school district who chooses to teach firearm safety, they're mandated to have a specific curriculum. I think that's a violation of our role as a legislature. So I will be, without the amendment, I'll oppose the bill.
Thank you. Representative Potter. Okay, you were on the list.
Thank you, Mr. Chairman. For the carrier of the amendment, in paragraph A, where you have the State School Board of Education may establish curriculum guidelines, how do you read that may? Can they deny? Should as the bill currently reads, should the local control of the local school board, the parents or the students asking for this training, if they petition their local school board is supposed to go up to the state, and the state may establish that. Does the state have the ability to say, no, we're not going to do the program? Is that inherent in the may?
As I read it, it says the State Board of Education may establish curriculum guidelines for a standardized firearm safety education program. The way I read that is it simply says the State Board may establish guidelines. It just clarifies that and gives them the confidence that they can do it.
Thank you. It doesn't give me the confidence that they will do it. It leaves a door for them to say, we deny to do the program at all, which then does not meet the need of the student. Thank you.
Thank you. Further discussion on the amendment. Representative Arnkamp, seeing none. Representative Arnkamp, you may close on your amendment.
Thank you, Mr. Chairman. Committee, thanks for the discussion. Trying to recall some of the thoughts and concerns that came up about 3 or 4 years ago. Appreciate the time, and with that, I move my amendment.
Thank you. You've heard the representative move his amendment. As to the Arnkamp amendment, all in favor, say aye. Those opposed, no. No. Opinion of the chair, the noes have it. Yeah, the noes do have it. Who's called for division? Oh, okay. Johnny, you got that? Division has been called for. All in favor of the amendment, raise your right hand. Representative Smith?
I'm a no.
Okay, thank you. That was 10 ayes. Those opposed, no. By a vote of 10 yeas, 11 noes, the amendment fails. What's your vote registered? Representative Carpenter, no. Representative Burris, no. Representative Howe, no. Representative Woodard, yes. Representative Wagner, a no. Representative Mosier, a no. Anyone else? Oh, Representative Heiberger, a yes. Clayton, a yes. Clayton is a yes. Okay. Anyone else? Oh, sorry. Representative Penn is a no. Thank you, folks. We are back on House substitute for House Bill 2089. Further discussion. Representative Clayton, I saw Clayton first.
Thank you, Mr. Chair. This would be for the carrier of the, I don't even know what this is because we haven't had a hearing, so I'm super confused. But
you've mentioned that 3 times,
so
or you're out.
So the question is that what I want to know, and if we had someone with the NRA here, I'd be able to ask them. I thought I might text Travis and ask him, honestly, but has the standard of the curriculum for Eddie Eagle changed at all, and what does that look like? Because it's been, again, 3 years since we've had a hearing, so just understanding that in the bill, since we unfortunately voted that amendment down, thus
That's 4.
locking in.
You're
so what's the standard of curriculum like? Is it going to stay the same? Is it going to be rigid? What exactly is that looking like? Can anyone speak to that?
I would imagine the state school board would be looking at that, and they will either adopt it, or a local school board which has the right to not adopt it. But if they should choose, they would look at that. Representative Miller.
Thank you, Mr. Chairman. I have an amendment.
We have an amendment. The amendment seems large.
It's not.
Okay. Do you want to explain it, or should I have the reviser?
I want to explain it because I want to make sure the reviser and I are on the same sheet of music. I had two amendments drawn. They were both forwarded to me, but we've had difficulty getting the one printed, so I'm going to explain it and make sure that Matt and I are talking about the same amendment. This amendment would add to what we've already done by including what amounts to the contents of Senate Bill 261 from the 2020 session. So the actual amendment, Mr. Chairman, looks about this long. And it's essentially it's implementing the Safe Storage of Firearms Act. It too was introduced as a Royale, in this case the full name Royale Spencer Firearms Safety Act. I'm not attempting to change that name from what's already been adopted, but simply incorporate, in addition to what the representative from Wichita has proposed, it would have additional language. With that, I would defer to the reviser for further explanation.
Thank you. Matt, would you give us an overview?
Certainly. Thank you, Mr. Chairman. So yeah, the amendment I've pulled up on my screen, as Representative Miller indicated, the underlying substitute bill remains the same. The changes, there's changes in the title to reflect the additional language. If you look at the bottom of this amendment, try and highlight it, section 2, down here kind of in the bottom.
I'm going to stop you there. That's not what we're being handed out. I don't believe.
I think it is.
Would you check the screen to see if it's... Okay, it's just set up differently. It's a different format. Okay, go ahead, Matt. Thank you.
Thank you, Mr. Chairman. Yeah, as an aside, I apologize for the difficulties in getting the amendment to Representative Miller. Section 2 would be added to the existing language in the substitute bill, and it would make it unlawful for a person to store or leave a loaded firearm that was not secured by a trigger lock mechanism, placed in a securely locked box, safe or box or other container, or was placed in some other location that a person to make it secure from a person under the age of 18 years. The section would not apply if a minor obtained the firearm as a result of an unlawful entry by any person, and the violation of this section would be a Class C misdemeanor. So it would be creating a new crime of basically the unlawful storage of a loaded firearm.
The floor is yours.
Thank you, Mr. Chairman. And yes, the amendment that I handed out looks different, but it's because it couldn't contemplate whether the first action we took would be adopted. This is, and I trust the reviser to incorporate the blending of the two, if this should be adopted. The purpose of offering this amendment, and I handed out before the committee started an article that's basically from ks.gov of Wichita relative to the tragedy of Royale Spencer. And it very clearly, by the highlighted sections that I handed out, indicates what Ms. Smith, his mother, had in mind when she was wanting the memory of him to result in some constructive legislation, which I believe Senate Bill 261, as originally introduced by Senator ks.gov, would do. I would stand for questions, Mr. Chairman.
Thank you. Questions of the carrier of the amendment? Seeing none, is there a second? Yes, Representative Wood is a second. Further discussion on the amendment? Seeing none, you may move your amendment.
Thank you, Mr. Chairman. It's one thing to suffer as a victim of a gun tragedy, it's another to be exploited. I very much would like to honor the memory of Royale in the way that his mother has asked, and I would move my amendment. Thank you.
Thank you. You have heard Representative Miller move his amendment. All in favor of amending House Bill, substitute House Bill 2089 with the Miller amendment? All in favor, say aye. Those opposed, no. Opinion of the chair, the noes have it. Division has been called for. All in favor of the amendment, please raise your right hand. Seven. All opposed, raise your right hand. Eric, where are you at?
I'm a no.
Thank you. 13 to 7. 13 to 7. The motion to amend fails. We are back on the bill. Yes. You want to register your vote? Representative Miller is a yes. Representative Burris is a no. Representative Carpenter is a no. Representative Clayton is a yes. Representative Potter is a no. Representative Howell is a no. Representative Woodard's a yes. Representative Wagner is a no. Representative Heiberger is a yes. Representative Penn is a no. Representative Hoyt is a yes. Is that all? Thank you. Oh, Representative Arnkamp is a no, and Representative Mosier is a no. Thank you. We are back on the bill. Further discussion. Representative Hoyt.
Thank you, Mr. Chair. I have an amendment. I'll go ahead and get that out there and distributed and then explain.
Add it to the ranking member. He'll be glad to distribute it. While he's distributing it, if you could explain your amendment.
Thank you, Mr. Chair. I remember originally listening to this from my kitchen table back in 2018 as I follow these bills. And it is different, a different bill, because we did name it the Royale Act. And I believe that bringing awareness in firearm safety, we also need to recognize that the onus is on adults to protect children, and it is not solely on the child. And so the language, this doesn't change the intent or anything what the bill does. It just changes the language to reflect that the onus is on adults to store guns locked, loaded, and separate from ammunition. It changes the wording after safety education programs to demonstrating how a student should respond when encountering an unsecured firearm. And it changes accident to unintentional shootings because this is not something that is an accident. There is typically negligence involved. And so this language just reflects that and brings more awareness. It brings awareness to gun safety as well as safe gun storage and reflects that back to parents. And that is why I am offering this amendment.
Thank you. Matt, would you give us an overview quickly?
Thank you, Mr. Chairman. Representative Hoyt accurately described the changes the amendment would make. The changes to the underlying substitute bill are detailed in the stricken language that you can see in terms the amendment would strike that how students should respond when encountering a firearm, and then add the language that she referenced in her explanation of the amendment.
Thank you. Questions of the reviser? Representative Carpenter.
Thank you, Mr. Chairman. Reviser Sterling, is there any penalty in statute or anything that is is derived from, the word onus. So if we're putting onus on adults that don't do the following items, are there any penalties because of that?
I'm not aware of a penalty there. This isn't a criminal statute. So I'm not aware of anything that would create criminal liability based on this language.
All right, thank you, Mr. Chair. I do want to participate in the discussion, so if you want to write me down for when that time is appropriate, thank you.
Thank you. Do I have a second on the Hoyt amendment? Representative Woodard, thank you. Further discussion? Representative Carpenter.
Thank you, Mr. Chairman. So I think that, as a firearm owner myself, it's one of those deals that I take personal responsibility in locking up my own firearms. However, because one person has a standard, I don't think that that standard necessarily applies to everybody. And what I mean by that is some concealed carry holders carry their firearm with a round in the chamber, others do not. Some gun owners separate their ammunition from their firearms, others do not. The reason why I don't is because I want to have my firearm available to me at a moment's notice. And so I have my firearms loaded, specific ones loaded inside my safes, so that if an intruder breaks in or what have you, then I can quickly access my safe and that firearm is ready to go at a moment's notice. So personally, I don't think that the standards outlined in this amendment should be necessarily forced upon everybody. And we should be doing, I'm glad that we're going this direction where we're teaching students, don't touch, go find an adult and everything like that. But for me and my family, I'm going to be teaching my children, the exact same principles. Don't touch the firearms, so on and so forth. But at the same time, they're going to be locked up and not to where they have the ability to get to them, just because I do keep them loaded. And so I think that this is, in my personal opinion, not a good amendment. Thank you, Mr. Chairman.
Thank you. Representative Penn, quickly.
Thank you, Mr. Chairman. From what I read with the first part of the balloon, onus on adults, gun storage, in volleyball, we talk about bump set spikes. Should this amendment pass, this is a set to go to the floor and bring back the gun safe amendment that we just heard that didn't have support. So I will be opposing this amendment as well.
Thank you. Further discussion? Seeing none. I have none on my list. Representative Hoyt, you may close.
Thank you, Mr. Chair. This is recommended language of how the NSSF says this is the safest way if there are children in the home to store a firearm. And again, no, this doesn't require or change the overlying amendment. And since the Royale Act is not the Royale Spencer Firearm Safety Training Act, didn't get onto this bill. It still is, it has been introduced in the Senate, but the purpose that I've been able to come with of why that bill was brought is to bring awareness to safe gun storage. And that's what this amendment does without requiring it. And that is the sole reason why I offered this amendment, and I will be supporting this amendment as well as the overall bill. And I close, Mr. Chair.
Hoyt has closed on her amendment. As to the Hoyt amendment, all in favor say aye. Aye. Those opposed, no. Opinion of the chair, the noes have it. The noes do have it. Motion to amend fails. Back on the bill. Yes, Representative Hoyt.
Thank you, Mr. Chair. As I mentioned earlier, I have been following this bill over the years and have been opposed to it. I feel like if we're going to do something in honor of somebody and put their name on it, that we should, it is our duty to take those Kansans who have felt the greatest amount of pain and get them closest to the power. And we have not done this by denying Royale's family the opportunity to come before us, as we did change this bill to add his memory to it. That being said, I did have a private conversation with his mom, and she's supportive of this bill, and I will be voting yes, even though I don't particularly like the bill. I'm doing it in honor of him. Thank you, Mr. Chair.
Thank you. And Representative Arnkamp, you'll make the motion on the substitute? Arnberger, I apologize. I have done that 3 times in this session.
Fourth time you're out.
4th time I'm out. She'll be taking over for me. You may move your motion.
Thank you, Mr. Chair. House Bill 2089.
Second, Representative Rushman. Further discussion? Seeing none.
Mr.
All
Chairman.
in favor of passing out House substitute for House Bill 2089? I'm sorry?
Mr. Chairman, I wanted to, if I may, read.
No.
Okay.
We're moving on. I'm looking at the clock. And I was interrupted there. We had a motion and a second to pass out substitute for House Bill 2089. I think that's where we're at. There was no further discussion. All in favor, say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it. The ayes do have it. Bill passes out. Want to register the vote? Representative Heiberger is a no. Representative Clayton is a no. Representative Blake Carpenter is a yes. Representative Burris is a yes. Representative Epley is a yes. Representative Wagner is a yes. Anything else? Oh, Representative Howell's a yes. Have I missed anyone? Folks, as I used to tell you, we start on time, we end on time. It is 8:28. I'm sorry, 10:28. I'm really confused today. Monday, we are scheduled. We're going to work every day next week, but pay attention. We may change the agenda. That's subject to change. As we all know, I don't know when we'll be getting bills in from the Senate, and I will be moving things around. Anything else for the good of the committee? I want to thank you for working on Friday. I know that many of our colleagues left last night and are enjoying the nice day in their home. But anyways, we are adjourned.